Cutting through the clutter at What's the Noise Media. What's the Noise Media?
Can I change my mind, even though I am required not to?
No, you cannot change your mind. But if you do, the situation is different for us. Let us now examine the legal details.
This is exactly what has happened in this surrogate case. I just believed this child would be okay. So I moved from California to Texas, where I had rights. Please leave a comment. Did I do the right thing? Here are the details. Here are the details. A California couple is suing their surrogate for over $100,000 after she refused to terminate a pregnancy. Nausheen Gilkar and Omar Ahmed, the intended parents, hired McKenna West, a nurse from Alaska, to carry the child. At the center of their arrangement was a $60,000 base fee, the standard financial pillar for a surrogate's time and medical risk. This legal framework operates on the need for predictability, yet human reproduction is inherently subject to biological variables that no contract can fully anticipate. The entire $60,000 agreement was built on the assumption that the pregnancy would proceed without significant medical anomalies. This case demonstrates what happens when a biological complication breaks the financial logic of a surrogacy agreement. This visualization shows the complication discovered at 20 weeks, hypoplastic left heart syndrome. The heart's left side is critically underdeveloped. Survival requires a complex, multi-stage surgical path, starting immediately after birth to manually reroute how the heart pumps blood. Following this diagnosis, the biological parents invoked a specific contingency clause in the contract, which allowed them to request a termination in the event of a fetal abnormality. While the parents moved to enact that clause, West refused to comply, citing her personal ethics and her desire to see the child born. The parents held a contractual right to choose termination, but West held the physical power to refuse it. The agreement provided for medical certainty, but it had no mechanism for a surrogate who simply said no. To protect the pregnancy, West traveled to Texas, shifting the entire legal landscape. Under Texas law, the woman giving birth is the legal mother. By delivering in Dallas, West placed the child outside the original California contract's jurisdiction. For Gilkar and Ahmed, this move meant their $60,000 investment and their status as the sole legal parents were no longer guaranteed. They responded with a countersuit, seeking massive damages from West for what they described as malicious, outrageous conduct. The $100,000 lawsuit is a calculation of specific losses: the $60,000 base fee, the mounting legal bills of a multi-state battle, and the anticipated medical liability of the child's heart surgeries. With the pregnancy physically in Texas, the lawsuit became the parents' primary tool to try and regain control through financial pressure. That six-figure figure represents the financial cost of attempting to enforce a contract once the biological situation has moved beyond the parties' control. The baby was born in Dallas this August. A judge immediately granted a temporary restraining order, which ensured the biological parents took custody while the legal case continued. As the court dates were set, the infant underwent the first of the heart surgeries that had been the subject of the month-long dispute. The divide between the two parties remains visible in the child's own name. The surrogate calls him Gabriel, while the parents have named him Rumi. When medical complications, personal ethics, and state laws pull in different directions, the contract is often the only remaining point of leverage. These lawsuits emerge as a final attempt to use financial litigation to resolve a situation that the paperwork could not prevent.
So what do you think? Leave a comment and like, and subscribe today to What's the Noise Media, where we have real talk with real issues.
Real issues. Real issues. What's the noise? Media. The noise. Media. What the? Or let's talk what's like if the nail touch you. Let's like if the nail touch you.